All right. Hi, everybody. It's Chris Flipper from On the Bus Sales Training, and welcome to our July Lunch and Learn. And we are featuring Alix Rubin today, and I'll get to that in a second. I just want to let you know some Lunch and Learns that we do have coming up. In August, we will have M&T Bank. Jen Peel will be giving us some information on the PPP loans, but she's really going to focus on financial literacy. And it's a program that she and I had discussed, and we're going to do a few of these each year. And M&T has been a very nice relationship with us and our members and all of you. I think it'll be an interesting program to teach us some financial literacy. Some are better at it than others. Me, I just go straight to the bottom line. I don't know what all those lines mean on all those sheets, and we'll learn. Doesn't sound like it's a laugh a minute, but you know what? It's important information that we should know. And so we're going to do that in August, and I think it's October. And the year's calendar is full. You can go to onthebus.biz and look in the events area, and you will see all the upcoming lunch and learns and all our events in general. So Alix and I met a few years ago. We used to share an office together, not really an office space together. And actually I moved into an old office of hers, and it was really her husband that sparked the relationship. We liked the same kind of music, and all of a sudden I was in a supermarket and this guy kept like wanting to talk, and I didn't know who he was. He knew who I was, and he's an interesting character, and a friendship was developed. And, Alix is somebody who I like an awful lot, but I've never found a way to work with her. And through LinkedIn, I saw these amazing videos she was posting. And they were really well done, and they were on time, topic-wise. They weren't too long. They weren't too short. They were just right. And I was like, you know what? I like Alix. She's normal. She's not like this aggressive lawyer type, if you know what I mean. There's no sleaze on her. And they were real topics with real solutions. So I invited her to come and do this lunch and learn, and I'm excited. And Alix, I'm going to give it to you. And you've got about an hour or so.
Wow.
And one question: how do you want to handle questions?
Yeah, I was going to approach that. So what I'd like to do is I have my presentation divided up into segments, and I've actually put slides. I'm going to be showing a PowerPoint that you can follow along, and I've put question slides in. So after each topic, some are a little longer than others, I'll put up the slide for questions, and then we can take questions. I didn't want to wait till the end because I think that's going to be hard for you to remember. Like, you had a question about something I talked about at the very beginning. So this way.
Okay. And so for those of us, our members that are blurters and like to blurt out, try to not do that. Just write down your question and ask at the appropriate time. Okay.
Yeah. Cause so your question might actually get answered in the presentation. And then if not, obviously, feel free to ask.
And down below in the participation area, there's a button there. You can click on that and raise your hand, and then we know that there's a question coming. So we'll start with those. Okay, Alix, take it away. Go ahead. Okay, I'm going to mute myself.
Great. So before I put up the PowerPoint, I wanted to ask a couple of questions of you guys. So how many of you have employees? If you could raise your hand. 1, 2. Okay. 2 of you have employees. Okay, great. And how many of you know people who have employees? That would probably be everybody, right? And how many of you know people who are employees? Probably just about everybody. And okay. And then the last, I don't imagine any of you are employees. You're all owners of your own businesses. Is that right? Okay. All right, I just want to know who I'm talking to, and so I can gear it appropriately. So this really is, I geared it mostly to employers, people who have employees, but obviously you can extract from it, as an employee, if you know employees. And then of course, if you know other businesses who have employees, we'll find this information useful. So let me pull up, let me get my slide up on my screen so then I can share it with you.
I'm going to ask, could everybody mute themselves, Ed, you too, because as you make noises in the background, it switches to speaker mode.
Ah, yes. And I have permission to share, correct? Yes, I'm good here. Okay. Let me move this so you can all see it. All right, hold on. Got to find the right. I'm seeing part of my desktop background there. Okay. I'm going to move this. There you go. And let me just put it on slideshow. Whoops. Give me
David Quick, any suggestions?
Yeah, I'm trying to find this where it.
I'm pausing the video.
Okay. It's not exactly how I wanted it, but let's see. Use slideshow, maybe. There we go. That's exactly what I wanted. Okay. All right. So today I'm going to talk to you about employment law issues during COVID and beyond. I'm just going to give you, oops. No way. There we go. So just a little bit, some boring legal stuff that I need to tell you. This is for informational purposes only. I'm not offering you legal advice. It's not intended to create an attorney-client relationship with any of you. You need to consult with competent local counsel to determine how these matters may affect you. All right. So what we're going to cover today, I'm going to start off with the sick, family leave, and unemployment benefits under both federal and New Jersey law. Just a little warning about that. It can get a little boring. I'll try to go through it relatively quickly, but I think it's important information, you know, to have an overview of what's available to people if they can't work during COVID. That's probably the longest segment. And then after that, I'll take questions. And then the others are shorter, and you know, I'll take questions after each one. So after that, we'll talk about furloughs, layoffs, the New Jersey WARN Act, how that all interacts. And then we'll start talking about bringing employees back into the workspace, how to keep them safe, to test or not to test, what tests can you do and what tests can you not do as an employer, and then what to do and what not to do if an employee or a visitor to your workplace gets COVID. So with that, I'm going to start with the benefits. So sick leave benefits under federal law. This law went into effect April 1st, and it stays in effect until, at least as of now, until the end of this year, the end of 2020. Who knows if that'll get extended into 2021? I think it's all going to depend on, you know, what happens with COVID. It's called the Familiesfirst Coronavirus Response Act. I'll just refer to it as FFCRA. Provides 80 hours or the 2-week equivalent of paid sick leave for a part-timer at full pay, but only up to $511 a day if the employee cannot work or cannot telework because he or she, and there are a number of categories, is subject to a government quarantine order, has been advised by a healthcare provider to self-quarantine, and now that's going to come up now if people are traveling to some of the hot spots in the country and they have to, you know, in order to come back to New Jersey, they have to self-quarantine for 14 days. So that's a new wrinkle that's in effect right now. Or the person, for obviously, is experiencing COVID symptoms and seeking a medical diagnosis. So they don't have to be diagnosed with COVID to qualify for these benefits. They just have to be experiencing symptoms and seeking a diagnosis. In addition, this new law, FFCRA, provides 80 hours, the same thing, or a 2-week equivalent of paid sick leave for a part-timer. But for these reasons, it's only 2/3 pay, and it's only up to $200 daily. And this is if the employee cannot work or telework because he or she is caring for someone subject to a government quarantine order, is caring for his or her child whose school or daycare or camp is closed, or is experiencing any other COVID-related condition. We're still not 100% sure what that means, but there's been some flexibility built into this. I'm going to talk about, well, let me jump. I'm going to jump to family and medical leave benefits under federal law, which is, again, this is just for childcare. If and for employees who've worked at the company for at least 30 days, they get an additional 10 weeks on top of the initial 80 hours or 2 weeks of paid family and medical leave, again, at 2/3 pay, up to $200 a day. And this is to care for their child whose school or daycare, and now whose camp is closed. So what do you need to show, to prove that your child's camp is closed? Just like with the school closing, you need to provide the name of your child, the name of the camp or school or daycare that's closed, and why you can't, well, first, that nobody but you, that you're the only person who can provide the care for the child, and then why you can't work or telework, which probably is going to be, at that point, it's going to be obvious. With a camp, it's a little different than a school or daycare. You don't necessarily have to have already registered your child for the camp. I'm talking as if you're the employee, right? If before the camp closed, right? I mean, what if you were planning to register the child and then the camp closed, so obviously you didn't register the child? Well, if you can show that the child attended camp in previous years, in particular, like last year, right? And the child would still have been eligible to attend this year, that usually, that should work. So that's a little nuance there. Just so you know, these benefits do not apply to everyone, right? Certain companies with 500 or more employees are exempt. Now, you're probably wondering, why is that? Why are the big boys exempt and only the smaller employers have to comply? That doesn't seem fair. Well, I think first of all, because it's a Republican Senate, and I don't want to get political about this, which tends to be more favorable towards larger companies. But the other rationale, I believe, was that larger companies already have pretty generous benefit packages for their employees. And to their credit, some of them are doing something, the equivalent of this anyway, and certainly they can afford to. So I think that was the rationale, that the government didn't have to require them to do so. There's another wrinkle too, and that is that when the employer provides these benefits, that the employer gets payroll tax credits for the benefits. And I think the government felt that they didn't want to, give those tax credits to the larger companies. Healthcare providers are exempt for obvious reasons, because they need to have as many people working as possible. First responders, the same reason. And then any company that provides equipment or supplies to a healthcare provider. So any company that makes PPE. A lot of companies have pivoted in order to do that because of the huge demand and whatever else they were. I'm sorry, I just jumped the slides. Hold on. Whatever else they were, producing is no longer in demand. So, those companies would be exempt from this. And then companies with less than 50 employees, for which this would jeopardize the viability of the business, but that's only for the childcare reason. The 2 weeks they would still have to provide, but the additional 10 weeks, which could be a hardship for a small company. They would not, you'd have to be able to show that as a small employer. So who pays for this? I think I touched on this a little earlier. The employer pays for these benefits, but there's a dollar for dollar payroll tax credit that's given. Just keep good records. You do need, again, with the school closing or the camp closing, you need to have, the employer needs to have those records of, the government might ask for them down the road. You need to have records of, why you took the credit for the payment of these benefits. Self-employed individuals, so for those of you who don't have employees, are also eligible for tax credits. So if you yourself would have to, take time off for these reasons. You can't double dip. When I'm talking about double dipping, I'm not really going to talk about the, PPP loan, but the Paycheck Protection Loan, except in this context that if you're receiving payroll tax credits for paid leave benefits under FFCRA, you cannot use that as part of your request for forgiveness of the Paycheck Protection Loan. I actually just learned this morning in another a Wharton Club networking meeting I was part of that there is that Congress is considering a bill that would just automatically forgive all the PPP loans under a certain amount, probably under 150,000. Of course, we don't know if that's ever going to pass, but that is under consideration. So I just thought I'd pass that along. So now I'm going to jump to this. On top of all these new federal benefits, there's, employees still have their sick leave benefits under New Jersey law, which, as you may already know, is 40 hours a year. So employees can still use these 40 hours of their, as long as it's been accrued and it hasn't yet been used this year. For these additional reasons, aside from the employee, him or herself, being sick or having to care for a sick child or a child whose school is closed or camp at this point. If the governor ordered the company to close, if the company stays open in defiance of such an order and the employee chooses not to work, if the employee is in an essential retail business that decides to stay home, the employee decides to stay home to comply with social distancing. So, for example, if the essential retail business is not taking all the precautions that, both the state and the CDC recommend, a healthcare worker who's advised to self-quarantine, would be able to use sick time, or an employee who needs to care for a family member who has COVID can also use their 40 hours of sick time. And this is, or who was quarantined, if the family member is quarantined due to COVID. And this is over and above what the federal, those federal benefits we just talked about. Under New Jersey law, there are also family leave benefits. And you'll see there's something interesting about this. And that was just recently expanded to 12 weeks of leave to take care for a family member with a serious health condition, which now includes a diagnosis of COVID or exposure to someone with COVID. The amount just went up July 1st. It's now 85% pay, capped at $881 per week. And the leave is job protected if the employer has more than 30 employees, meaning that you have to, as the employer has to keep the job open, for the 12 weeks at a minimum. So it's possible that these benefits would be higher than the FFCRA, the federal benefits. Again, that's a calculation that employers and employees need to make. Which benefits are more beneficial for the employee? The employee is going to make that calculation. The employer is going to want to use the federal benefits first because you get the payroll tax credit for that, which you don't get for family leave. Although, again, the different, which doesn't really matter. I would say, I'm going to take that back. It's actually a wash because the employer doesn't pay these benefits. The state does. It comes out of the state fund. The state, the FLI, that if you get a W-2, the FLI that's taken out of everybody's paycheck every week or every other week, that's family leave insurance. That's where it comes from. So the employer doesn't have to pay it. So in a sense, it's a wash because if the employer is paying the other benefits, the federal, you're getting a payroll tax credit dollar for dollar. So either way, it works, but this works better for the employee. Unemployment benefits, I'm not going to get into the weeds on this. There's a lot. I could do a whole webinar on this, but just keep in mind the $600 weekly supplement is only through July 31st. That's going to stop unless, of course, Congress decides to extend that, which they're considering that, but who knows? They're on a break, July 4th break right now. I think they're due back in a week or two, and then they take their August recess. So we'll see. They did approve a while back an additional 13 weeks of benefits, so it's 39 weeks total. And furloughed employees are now eligible, which they never were before, for unemployment. There's also, on top of state unemployment, federal government issued pandemic unemployment assistance, which is available to independent contractors who can't work or, are not, are not, don't have any work, or their work has, has diminished significantly. If a job offers was made and then it was rescinded due to COVID, if the individual became a breadwinner due to death in the family from COVID, if the individual quit his or her job due to COVID, or, doesn't matter. They're not looking at your work history. It used to be you had to have a certain amount of work history to qualify for unemployment. You don't need that. Employees don't need that anymore. So we're in an interesting predicament, vis-a-vis employers and employees whereby, now that some companies, they want people to come back to work. They've maybe furloughed people or laid people off, and now they want to bring some of them back. And they're getting this enhanced unemployment. In some cases, particularly lower wage earners are making more money sitting home. And so they're thinking, well, why work when I can make more money at home? Why expose myself, right? By going back to work if I'm making more money at home. The only problem with that for the employee is, unless it gets extended, that's not going to be true after July 31st. That $600 supplement will go away, and then they'll only be getting 2/3 of their pay on unemployment, up to a maximum of, I think it's now in New Jersey, it's $713 a week, something like that. So it depends on the salary. But the other issue is, well, if the employee doesn't go back to work when the employer asks them to, they're going to be fired. And then, when unemployment runs out after 39 weeks, they're not going to have a job. And it may be difficult to get one in this climate. So that's another consideration for the individual. For the employer, it's difficult, because then if they like the employee, and they want them to come back, to have to hire and train a new person, that always costs money, time and money. Chances are, though, if that's the attitude of the employee, you probably, as an employer, you probably don't want them to come back, So, on the one hand, maybe you can't blame them, but on the other hand, well, they're not really dedicated to their job and to your company if that's their attitude. That's my take on it anyway. And the other thing is, the employer can report that to unemployment, and their unemployment may actually get denied because of that. And then one more wrinkle on the PPP loan, you have to maintain your head count in order to get the PPP loan forgiven. If this, reduces your head count, it won't count against you. You may have to show that, that this employee refused, keep good documents. Again, make sure you have it in writing that you offered the employee, the ability to come back to work, and that the employee declined it. So that's that. I'm ready for questions about anything I've talked about so far. I think everybody's muted, so unmute yourself.
I have a question. So do you happen to know what goes into the fact that they would extend this unemployment or not? Is it just really like a crapshoot? Is there?
That's a good question. Whether Congress decides to extend it or not. On the one hand, I'm thinking they might, because the COVID rates are spiking in states where they were very low when they initially passed it. And even though, we're fortunate that our rates have been down, although we're now just above 1% again, or 1.0, whatever that ratio is, that 1.0, which is not great, but we're much better off than Texas, Florida, some of those other states that are spiking. I think there's 16 now that we require the quarantine. if you're coming from there. So I'm thinking, so, you know, the Congress people who are from those states who maybe would normally resist it, now that it's in their backyard, might actually be inclined to extend it.
And it can never be, it always has to be a national rollout. It can't be based on state.
The $600 supplement, yes, that's federal.
Okay.
The states are not footing that bill. The federal government is. That's under the CARES Act.
Thank you. Just for the clarification.
It looks like Renee has a question.
Yes, I have a question. Can you hear me?
Yes.
Okay, so this actually yesterday, I had one of my clients ask me this question. So I figured, great, I'm coming here today, I'm gonna ask you a question. So it's a bar restaurant and they're doing, you know, just the outside, you know, seating and drinking or whatever. And she has an employee who had recently visited a hotspot and is deciding to self-quarantine for 2 weeks. Does she need to pay them? Or should she get some backup, like maybe have them go for a COVID test? I mean, she doesn't know whether she should be obliged to pay them.
Okay, so two things. One is, I thought it was interesting that you said that the employees has decided to self-quarantine. That's actually required. I know it's not being enforced in New Jersey as strictly as it is in New York, is my understanding, but she's actually required to self-quarantine. And I think the employer, the restaurant should require the employee to self-quarantine, just to protect their other employees as well as their customers. Although I would, again, a negative COVID test might be another way to go. Except, you know, sometimes people, it's interesting because I actually have a colleague who I was just on a Zoom call with this morning, who he's almost 100% sure he had COVID back in March. And when he got tested back then, it came back negative. And he had all the symptoms. He was sick. Now that he's been tested for antibodies, he does have the antibodies. So, you know, tests are not always 100% reliable. I think they've gotten better with the testing since March. And you know, you might test negative one day and positive the next, right? So I think the 14-day self-quarantine is the way to go. As far as benefits that the employer has to pay or that the employee is eligible for, if the employee hasn't used up their federal benefits, they would be eligible because that's a government-ordered self-quarantine. So they'd be eligible for it's 40 hours. So that would cover the 2-week quarantine. They're eligible for the 40 hours at full pay.
If they hadn't, because I think as employers were required when the thing hit to use up everybody's time, right? So if they had already used up their
Right.
allocated, then they can't use it again. Like, in other words,
Correct.
used up. So she isn't required to pay them if she already paid them before the.
Well, it's 40 hours. Yeah, I'm sorry. It's 40 hours under the federal law, under FFCRA, but it's also another 40 hours, you know, regular New Jersey sick time. That it could also.
Oh, so that's 80?
It's really, yeah, it could be. I'm sorry, it's 80 hours under, hold on. It's 2 weeks. It's 80 hours under the federal. I misspoke. It's 80 hours under the federal law and it's another 40. So depending on what they've used, right?
Okay, so someone, like if it's a part-time person, what do you gauge on how many hours they normally work?
Yeah. It's
okay.
It's under the federal law, it's the equivalent of 2 weeks of their part-time work. It would be that many hours. So let's say if they only worked a 20-hour week, then it would only be 40 under federal law.
Okay.
But then
All
the
right.
40 of paid sick leave. And then that's, I mean, again, depending on what their allotment is of paid sick leave for the year and what they've used or haven't used. Now, the employer doesn't have to, but the restaurant owner could also let them use their vacation time, their paid vacation time for this. But they don't have to, but they could let them do that.
Okay.
So I have a quick silly question. You know, my brain, I think through COVID, I've taken on so much new information that a lot of the earlier information has washed away. And, you know, so if it's a dumb question, it's a dumb question. But the PPP money that many people got at the beginning of this thing, how was that supposed to be used? If I recall correctly, there was some stipulation that 75% of it needed to be used for either business or personal. I forget what it was, but what was the answer with that?
Yeah, sure, Chris. So first of all, there are no stupid questions, right? Every question's valid. And I'm glad you brought that up because that has actually changed. So the PPP money, it was originally 75% towards payroll, 25% towards rent, mortgage, and utilities.
But if you were your own employee, that could be 70, you paid yourself.
Correct. Now there is a
Okay.
limit. The limit is 100,000 a year, which now is 20. Now that they've extended it from 8 weeks to 24 weeks, it's the limit is 20 for the whole time is 20,000. I think it's $20,833. It's just over $20,000. For anyone who's self-employed or any individual employee, it's capped at 100,000 a year. So, but now they've changed the percentages. So now it's 60% towards payroll, 40% towards rent, utilities, and
So they're trying to help the landlords, it sounds like.
I think so. Yeah, I think so, and just make it Or if
So now, with the rules changing, does that mean we need to reapply, or do they automatically send it? How does that work?
no, you do not. If you already received a loan, you do not need to reapply. That's going to figure in on when you apply. You do have to apply for forgiveness, but you have until, I believe it's until April 2021 to apply for forgiveness. And
Yeah, I mean the additional money. So
You're
now
not going to get any additional money.
there is no
They're not.
additional money. No.
No.
Now, if you
Well,
haven't,
but I keep hearing they're going to re-release more money.
yes, and there is still money left. There's still, I believe it's something like $130 million that hasn't been used yet. So if you haven't applied, go ahead and apply. Get the money. You can still get the money. They did just extend the deadline. The deadline was originally June 30th to apply. It's now, I think it's August 8th. I think it's August 8th is the date. But double check that. Renee, you're probably up on this.
So I was really asking for a friend, and the friend happens to be on here. So there's the answer we were looking for.
Okay, good. All right.
Thank you. Let me keep going.
Yeah,
I have one question. Thank you so much for answering these. We appreciate it very much.
sure.
So, I only have part-time employees, and I've had a couple of my team members ask me to go and pay them quote unquote under the table because they're collecting unemployment, and they were told by either another part-time job or their full-time job that they wouldn't be able to collect unemployment if they're collecting even a part-time. Now, most of my team members, some of them are only working a few hours a week, even maybe as little as 2 or 3 hours. So it's not a ton of time. Can they collect, and I can't really seem to find the answer to this, can they collect unemployment and work a few hours a week for someone, or does it dramatically affect them? Because they're saying, well, if it's a wash, why should I work?
Yeah. So the rule has always been if you work as an employee, if the employee works less than 32 hours a week, and what they're earning by working less than 32 hours a week is not equal to what they would be entitled to under unemployment, then the employee gets the difference. So the first rule is it has to be less than 32 hours a week. So like you said, if they're only working, if they're working 2 to 3 to 4 hours, whatever it is a week, that, they can still collect unemployment if what they're earning is less than what they would collect under unemployment. Then they would get the difference. So they would still get the same. I understand what they're saying. They would still get the same amount that they would get if they didn't work. Actually, no, that's not true. What unemployment does is they add a percentage, and I forget how much it is. I think it's about 10%. So they bump up. So there is more of a differential, so that they don't want to create that incentive, right, not to work.
Yeah, well, because that's the thing, is like they're like, okay, well, I have, and many of them have full-time jobs, so they'll work 40 hours a week, and they've been furloughed or let go
Okay. Mhm.
from their full-time job, and they work for me just a few hours a week. So they're like, well, if I'm making, and just round numbers here because I don't know what they're making, but say they're making $500 a week
Right.
because it's a full-time job, and they work for me and they make, I don't know, $80 every week or whatever. Is it going to be 500 minus the 80? Because
Yeah, it would. Well, yeah, but what unemployment does,
I get it. So
yeah, well, except that what unemployment does is they bump it up. So let's say, I think the maximum is now 713 a week. So let's say they bump that up by another $70, right? So let's say it's, $780 a week, right? So if they're earning, by working for you 2 to 3 hours a week, they're earning, I don't know, whatever they're making, that would get subtracted from the 780, not the 713, but the 780. So so they would get a little more than what they would on unemployment, even though they're working. But here's the thing, it's fraud for them not to report their hour that they're working and getting paid for that.
I honestly don't feel comfortable.
And and I should have said that at the very beginning, don't do it, right? Don't.
Right. Like I said to them, I'm like, that could be tax fraud. And frankly, I can't take that risk to do it. What about like deferment or something like that? Is that still considered fraud? Like if you don't pay them so they can collect and then pay them a big.
Yeah, that would still be fraud, and it would be against the wage and hour law too, because you're supposed to pay them in a timely fashion.
Yeah.
So yeah, you don't want to get involved.
So what I was going to say, and I'm not a lawyer, is when you hear under the table, don't do it.
Yeah.
Right. That means there's something sketchy going on there.
Yeah, I agree. I do know one of my staff members told me that her full-time employer is letting her collect unemployment, and this is a doctor, letting her collect unemployment and paying her, like deferring her paycheck, so she's just going to get a big lump sum. And I'm like,
no, yeah, that's bad.
All right, I want to keep it moving so we don't run out of time, but I'm going to ask a long-winded question at the same time. And again, I'm asking for a friend, but she just walked away. Okay, there she is. So asking for a friend.
A friend.
And this rule/law, I guess, was in effect prior to COVID and everything being Zoom. But if you have an hourly employee, it is my understanding that you cannot ask them to work less than 3 hours. That you can't ask somebody to go to a meeting, a mandatory meeting where hourly employees would go and they need to get paid if it's an hour meeting. They must get paid at least 3 hours to attribute for the travel time. So you couldn't ask somebody to travel by bus, let's say, or train to get to an event, and then it's only an hour they're getting paid for, and the commute may cost them more than they would get for the event. Is that being accounted for with Zoom, or is there still a 3 hour minimum?
Boy, that's a great question. I actually think it's 4 hours, not 3. And that is a great question, and I don't know the answer to that. I'd have to.
Can you get back to us on that? Because a lot of people here have hourly employees.
Yeah.
Yeah, like that would kill my whole company. I'd have to go out of business.
But you can't have somebody work an hour. That is not okay.
For somebody an hour a day. I mean, it's a daily
right.
thing, right? It's a daily, not a weekly thing. It's a daily thing. Yeah, and that was when, assuming the person was not working remotely, coming into the office. I think it might. Yeah, honestly, I don't know, but yeah, I'll take a look and see, because that's an interesting question.
I have a question.
Yes, Sarah.
So I own my business, but I pay myself with like a W-2. And with all of this, I've cut my pay because of lack of work. Because I'm the employer that cut my hours and also, I guess, technically considered the employee, am I eligible for unemployment?
If you cut your hours below 32 a week and what you're paying yourself is less than what you would be entitled to under unemployment, and with the little bit of a bump up, yeah, you would be entitled to.
Okay, it just feels weird.
It is weird. It is weird.
But as long as I cut it enough and I qualified,
yeah,
I technically can act as a normal employee, even though I'm technically the employer.
Yeah, you can. And that's what's changed under COVID. The other good thing, and this is just under COVID, is it won't get counted against your experience rating as an employer. Unemployment, because so many people are applying for unemployment now, and so many people have had to be, furloughed and let go, that so that's not a concern either. Okay.
Just feels weird.
Yeah.
So
Chris,
Alex, I want you to keep an eye on the time because we're already at 5 of 1.
Oh, wow.
So if you want to jump around,
Yeah,
maybe get to some of the hot spots. Go
yes,
ahead.
let me move on. So to furlough or not to furlough? Look, obviously, as I mentioned, either furloughing or laying off an employee will qualify them for unemployment benefits. You want to furlough people to maintain morale, and if you believe you'll be able to bring them back, you can also continue, if you do provide benefits like healthcare benefits, you can continue that for furloughed employees. Obviously, check with your health insurance carrier. They've extended that. I don't know how much longer they're extending that. Obviously, if someone's not a good performer to begin with, lay them off. You don't want to bring them back. Just a word about WARN and the state of emergency. So WARN stands for Worker Adjustment Retraining Notification Act. It's a federal law, but New Jersey has its equivalent, which is a long title. I won't even tell you what that is. I think it's a Millville, Dallas, something or other act, named after the factory that was the subject of a case about it. But anyway, during the state of emergency, the WARN Act doesn't apply. The WARN Act means that employers who are laying off 50 or more employees, which I don't imagine applies to any of you, but may apply to people have to provide, previously had to provide 60 days notice. The amendments that were supposed to go into effect July 19th, you would have to provide 90 days notice and pay employees severance of 1 week per year of service. What the state legislature decided to do, thankfully for employers, is put those amendments on hold. Number one, put the amendments on hold until 90 days after the state of emergency goes away in New Jersey. And number two, exempt any COVID-related layoffs from these requirements. So we don't have to worry about WARN during the state of emergency and 90 days after. Obviously, you want to keep your essential workers or those who can telework. So that's, the answer to that. Any questions on furloughs? Okay, I'm going to move on. Back to work, and this slide is chunk full of lots of stuff. So face masks, who should provide them? Well, as you're going back to work, I'll give you 2 examples. I had some made up with if you could see it, with my logo on it, that I provided my employees for when we go back. I sent them out to my clients and my best referral sources, really as a marketing tool. But and a lot of companies are doing that. They're making up their own, or getting made obviously their own and putting their logos on them. I've seen them. I'll give you 2 examples. Interestingly, my son works for an online publication. He works from home, always did, except when he has to go out and cover. He's managing editor and has to go out and cover stories. His employer, you know, she's a small franchisee. She gave him a mask. She sent him one. His girlfriend works in a restaurant. She has to provide her own. I mean, I think it's only right that the employer provide them, but there's nothing in the law that requires it, right? But if you want to encourage face mask wearing in the office, or, you know, at certain times when people are congregating, hopefully, so, you know, should be social distancing, provide them. Can you take employees' temperatures? Absolutely, yes, you can. You have to decide as an employer if you think it's important to do that, how much contact do they have with each other, with the public. Can you require virus or antibody testing? You can require COVID virus testing. You cannot require antibody testing. I'll just leave it at that. If you have questions, we'll get to that. Can you monitor symptoms? Absolutely, and I recommend you do that. I recommend that you have employees every day sign off that they don't have any of these symptoms, that they haven't been in contact with anyone who has any of these symptoms or tested positive. May want to consider, you know, again, for you guys, you don't have a lot of employees, it may not be an issue, but for other businesses that you know, it could be an issue. They may need to alternate shifts to reduce the number of people in the workspace, you know, who are there at the same time. Stagger lunchtime so everybody's not congregating in the lunchroom or kitchen at the same time. Reconfigure work areas so they're more spread apart, right? Put up plexiglass if necessary. Disinfect, you know, have policies, have specific policies about disinfecting surfaces that everybody touches, right? You know, have those disinfectant wipes handy, you know, available throughout the office so that people can wipe down their keyboards every morning and every night, their mouse, their desk area, anything they touch that everyone else touches. Hand washing policies, same thing, have hand sanitizer available, or, you know, or, you know, I think both really, if you have a sink, if you have access to a sink and, you know, soap and water, but hand sanitizer for sure. And then what if somebody gets COVID who works in your office or visits your office? What do you do? This is, I'm going to go into a little more detail about this because this is really important. You still have to protect the person's privacy. That's health, you know, that's protected health information. And yet you need to notify people who you know have been in contact with that person. So again, you know, the health department is supposed to take care of this, but I think employers should do their part in safeguarding their employees and any visitors, and letting people know. And, you know, you find out from the person who is diagnosed, who were you in contact with the last 2 weeks, in close contact with, right? And then you notify them that without giving out the name, they may know. If it's a small office, they're going to know who it is, but you don't tell them who it is. And that way, and any records, and you want to keep records about all this stuff, you know, those have to be kept like any other medical records. Keep them in a separate file, need to know basis, you know, for people who are going to access them.
I have a quick question.
Yeah.
Are we allowed to ask questions? Well, it looks like you changed slides. So are we the ones who report to the health department? Is that our job?
Actually, no, it's the healthcare professionals report to the health department. But I think it's still and they usually tend to take over from there in terms of contact tracing and notification. But I think.
So when you say that, you mean the person's doctor?
Yeah.
Whoever's diagnosing them will then report it.
Yes. Yeah, they have to do that.
Right. And the rest of everything else is just really common sense and making everything as safe and effective as we can.
Yeah.
And show that we've done something differently. Yeah,
and that'll protect you. Now they're considering a bill in the state legislature right now to, you know, to shield companies from liability if someone contracts COVID in their workspace. You know, as long as they didn't do any, you know, as long as they followed basics, you know, practical CDC and state guidelines.
What about the other way around? What about someone like Lois who's sending trainers to people's homes? What if one of the trainers picks it up from the client?
Well, unfortunately, I think that's an occupational hazard. But the trainer could still, potentially sue you, Lois, because that's part of their work. But really, ultimately, that's a workers' compensation claim, is what that really is.
I don't
And
know.
David,
How can it be
Dave,
if you're giving them the option to stay home and
Yeah,
they're choosing to go out?
there you go. So you get
I'm not requiring anybody to go out. And
good.
then I also have a question when you have a second.
Yeah, sure.
So one of my trainers told me, who is going out to see clients, he called me and said, Lois, I was at a family party and someone called me the next day, yesterday, that was the day after, and said that they were exposed. What should we do? And I said, listen, we have to be safe 100%. And I said, I'll call the client. It happened to be a couple clients that he worked with who are both like over 80. And he has a couple of other people that he's working with virtually, but these two are working in person. And I told him, I'm like, listen, we're going to just take a pause until he gets tested. And he went on his own, he got tested. But I also said to him, I'm like, you still need to be able to be mindful of your environment. And, it's really difficult, like, to send my team out because, like, they're at risk, but if they're going out in their personal life, like, how can, it's like, it's a calculated risk that I personally wouldn't take with the elderly. But if the elderly wants us to come and they've signed a waiver, like, and the trainer knows that it's a calculated risk and they're supposed to wear a mask.
Yeah.
Do I have liability there?
I think as long as you're taking every precaution you can take as a business owner, right? And telling that to your employees that they should be taking. Look, you can't tell people don't socialize, right? But you can tell them, when you go out, if you go out, be careful and keep in mind who our clients are, right? Especially the elderly, right?
Yeah.
And yeah, go ahead, Chris.
So I want to jump on that. So Lois's employee calls her up and says, all right, the test came back, cool, I'm good, I'm going back out, send me out. So Lois, just takes his word for it? Shouldn't he have to present some kind of documentation? What does that look like?
That's a good point, Chris. I think to be safe, for you to protect yourself and your business, Lois, ask for the documentation, for the copy of the negative test result.
Okay, just to keep it.
And keep it in, have a separate medical file that you're the only one who sees that. And,
Okay, thank you.
Yeah.
Okay. So what I'm going to suggest, hold on, Lisa, 1 second. So what I'm going to suggest is it's 1:05, and if it's okay with everybody, we have some extended time till 1:30 that maybe we should just take advantage of if everybody's cool with that. And now it's as long as you're willing to do that.
Oh,
we
sure.
can ourselves and not feel rushed, because I feel these are important questions and it's all worthwhile stuff here, and you're not boring us.
Oh, good. That's good to hear. No, I'm fine. I scheduled this from 11:30 to 1:30, so I'm good.
Hey, Chris, is it possible to take like a 2-minute break?
Yeah, go hide your screen and mute yourself. We're going to keep going. Go ahead, Lisa, you had a question.
All right, well, okay, so is the presentation over, and is there any information about waivers?
Nope, I
don't want to ask a question. What?
I have more.
I don't want to ask a question about waivers if it's going to come up.
Actually, I wasn't planning on talking about that, so ask away.
Well, waivers seem to be things that just came up with Lois. I am bringing people back, they're doing CPR on mannequins, let's say, or they're coming into a space where you can't eat at a space, but you can come into a business or go into a store. Do waivers protect me from telling people that, I would guess that it's I mean, nothing's impossible, but my mannequins, let's say, they have to be without a mask, but my mannequins are bleached and new lungs and there's an alcohol swabs, right?
Right,
What prevents somebody from saying that they got it from me
right.
unless they sign a waiver? How does waiver work
Okay. And I
legally?
apologize. That's my phone and the voice message going. So give it a,
We
No,
can't hear it, don't worry.
can't hear it. Oh, good. Okay. It's distracting me, but as long as you guys can't hear, that's fine. That's that VoIP, what I call my landline that we never answer. Oh, you know what? It's Friday. That's my mayor telling us, Mayor Tim Pesta of West Caldwell, telling us how many COVID cases we have. Fortunately, in my town, it's been steady for like weeks now.
All right, Alex, I'm going to reel you in for a second. Let's
Yes.
focus on Lisa's
Yes,
question.
absolutely. So yes, I'm sorry, Lisa. So,
That's okay. I'm
so
just, waivers are a big thing. I was just
yeah,
kind of curious
waivers.
legally.
And I've just been reading up on that. I think time will tell, and that's going to play itself out in the courts. There are, I've read things that say, why not? It can't hurt to have people sign off on a waiver. It may or may not be enforceable, may or may not be effective. Chances are, if somebody does have a claim, it's going to go to workers' comp, right? If they did in fact and can prove, and that's another issue. How do you prove where you got COVID from, right? Did you get it
Right.
from a client? Did you get it from your workplace, or did you get it because you were out in someone's backyard socializing? So that, and that chances are it's going to be a workers' comp claim. And as long as you can show that you did everything you possibly could to keep your employees safe, you followed the guidelines, you took precautions, then you should be fine. That doesn't mean you won't get sued, but if they can't prove that you were intentionally negligent under the, intentionally didn't do something that you should have done, it falls under workers' comp anyway. Now, there is this bill that I mentioned earlier that, may or may not come to pass, about exempting companies from any liability. We'll see what happens with that.
Well, and I do know anyone could be sued. I was just kind of wondering
Yeah.
personally, just because I'm in a situation where people are taking off a mask, period. It's like a restaurant.
Right.
So those waivers are kind of like a non-compete almost, or a non-solicit, one of those documents that the employee thinks is bulletproof and will hold up every time. But the reality is they just know they signed it, and that's in the back of their mind. So the waivers, you signed it or whatever it is. And
it may be, right. It may be, right. Something that'll prevent them from thinking about suing if they sign a waiver. And then there may be employees who don't want to sign it, right? And then you have to deal with that. So you got to weigh that out.
Thanks.
I hope that helped.
No, and I wasn't really 100% just doing employees. I was probably even doing participants, but that just,
right. It could involve, and in that case, workers' comp wouldn't come into play because they're not employees, right? So there's that too. Yeah, and that's a big issue. I mean, there was a whole issue with nursing homes about that, that has come up.
All right, thank you.
You're welcome. Any other questions? And I do have some more material, so I can just move on.
use your judgment just based on the clock on what you want to cover.
Yeah, no, that's fine. So next slide is just really, I am close to the end, so I'll ask again about questions. But just keep in mind that most employment laws haven't changed, right? You need to beware of disability discrimination. You don't want to be patronizing towards an older employee and say, well, I'm going to lay you off because you're 60 or older. And, I'm concerned as the employer that you're going to, I want to protect you, right? That's being paternalistic. And unless the employee, him or herself, is concerned, that's another story. And then, use objective criteria for rehiring, right? Use their performance, use what you need in your business, honor reasonable accommodation requests. So if an employee is afraid to come back and they do have an underlying condition, that makes them more susceptible to COVID, or they're older, you know, if they can still telework, then see if you can accommodate that, or maybe only come in a couple days a week. And then of course, you know, update your privacy policies and your practices for handling employee health information. Because now, unlike before, this is one aspect of the law that has changed, in that you can ask certain health, you know, COVID health related questions, require COVID related testing, all of these things. So you want to make sure, as an employers want to make sure that they keep this information as confidential as practicable. And I think we're basically, I'm at the end. So any other questions, I'm here to answer.
Questions?
Up, and Lois is back.
Yeah.
So
Any other questions? Lois, we just wrapped up, just so you know. So any other questions from anyone in the room? Ed Gunther, you go ahead, David.
Yeah, so if I supply my employees with masks, now it's like impossible to get the N95 masks, which are really the medical grade masks. So I supply them with the cloth masks, and they get infected if they get to the client, or the client gets infected. What's my liability?
Yeah, so as I said previously, if it's the employee, it's probably a workers' comp claim, right? So your liability is under your workers' compensation policy, as long as you know, took every precaution. Supplying them with masks is what the CDC recommends. Wearing masks, as long as they wear.
Even if the masks are inferior to the medical grade masks.
Yeah, because they're saying as long as everybody in the vicinity is wearing a cloth mask, that's sufficient.
The term they're using is face covering.
Face covering, right? And that's what they're saying now. Look, initially, as we all recall, they said you don't have to wear masks. Only medical personnel have to wear masks. And then they changed it, and they realized, no, it's airborne. Everybody should be wearing face coverings, right? And now it's required in public in New Jersey. So, you know, and you're supplying them. So I think again, it doesn't mean you won't get sued. It doesn't mean, you know, but there are a lot of hurdles that either the employee or the client need to jump through in order to prove their case against you. That doesn't mean it won't cost you money to defend, but again, I think your workers' comp policy, as far as an employee is concerned, comes into play here. And then if you want to get them to have them sign waivers as as a belt and suspender, well, then do that. It may or may not be enforceable.
Okay.
Any other questions? Going once? Twice? Alrighty, that's it.
Right,
Alex, thank you so much. That was great. Thank you.
You're welcome. You're welcome. So I wanted two things. One, if you would be kind enough to send me, and I promise I will not spam you, send me email addresses for everybody who is on the call.
Let's do it the other way around. Why don't you post your information in the chat, or everybody can post their information in the chat, and then you all can download it from there, and you're not relying on my technical fumbles.
Okay. And I just, yes, and I put my information up here, but I can post it in the chat too. Let me do that. Let me post my info in the chat. You can contact me.
And here's a little tip for you guys, just so you know, that if you post your information in the chat too early, anybody who comes on after you post it doesn't see it.
Right.
So when you're at a networking event, don't be the first to post your info.
Are you 100% sure about that? That when you go into chat, if I sign on late, that I can't see things? I'm not sure you're right.
I'm sure.
I have experienced that myself, yes.
Even if you go into seeing the whole chat, because I think I can.
You don't see the whole chat. You only see what you see. You don't know what you're not seeing.
This seems to be a Mac problem, because I can print the whole list at the end of the
That's
meeting.
Renee, I think I can too, and I'm on a Mac, but maybe I'm
Yeah.
not late.
So
I'm just
let's,
letting you know
I'm
what people
going
have
with
told
I'm
me.
going with the woman of the stars.
Okay, Lisa, you try to print the list. We'll compare notes.
But I wasn't late. It's a problem.
Yeah, it's whoever came on last, but it doesn't matter. You know what? I'm
So-
going to stop the recording. How about that for an idea?
that
Alex,
would be
thank you
great.
so much.
Oh, you're welcome.
Alex,
Thank you.
thank you.
One
Hold
other
on, I'll
thing
mute me.
One other thing
Okay.
I'd like to mention, and you don't need to record this, it's up to you, is anybody who needs more help, you can call my office and I will give you a strategy session for half price. So
And what is that phone number?
that phone number is, it's in the chat, 973-787-8442. And you'll talk to my assistant, Gail, and tell her that you're from On the Bus.
You're the best. Thank you for that.
Oh, you're